Today is March 23, 2026. In Dispute Resolution and Crisis Incident Management. Chapter 7 Arbitration Law, Republic Act Number 876. Our learning objectives. At the end of the lesson, students are expected to understand the following. What is arbitration law? Who is disqualified to arbitrate? Cases not subject to Republic Act 876. The form of arbitration agreement. The hearing by court in arbitration conducted. When may a civil action be stayed? How the arbitrators will be appointed. The challenge to the arbitrators and the procedures to be followed by the arbitrator. What is Republic Act Number 876? This act shall be known as the arbitration law. What are the subject matters of arbitration law? Two or more persons or parties may submit to the arbitration of one or more arbitrators and any controversy existing between them at the time the submission, and which may be the subject of an action, or the parties to any contract may, in such a contract, agree to settle by the arbitration a controversy thereafter arising between them. Such submission or contract shall be valid, enforceable, and irrevocable, save upon such grounds as exist at law for the revocation of any contract. Such submission or contract may include questions arising out of valuations, appraisals, and other controversies that may be collateral, incidental, or subsequent to issue between the parties. Section 2, Republic Act 876. Who is disqualified to arbitrate? A controversy cannot be arbitrated where one of the parties to the controversy is an infant or a person judicially declared to be incompetent, unless the appropriate court having jurisdiction approves a petition for permission to submit such any controversy to arbitrations made by the general guardian or guardians ad litem, or infant or of incompetent. But where a person incapable of entering into a submission or contract has knowingly entered into the same with a person incapable of so doing, the objection of the ground of incapacity can be taken only on behalf of the person so incapacitated. Section 2, Republic Act 876. What are the controversies or cases not subject to Republic Act 876? This act shall not apply to controversies and to cases that are subject to the jurisdiction of the Court of Industrial Relations or that have been submitted to it as provided by Commonwealth Act Number 103 as amended Section 2, Republic Act 876. What is the form of the arbitration agreement? A contract to arbitrate a controversy thereafter arising between the parties, as well as submission to arbitrate as existing controversies, shall be in writing and subscribed to by the party sought to be charged by his lawful agent. The making of contract or submission for arbitration described in Section 2 hereof, providing for arbitration of any controversy, shall be deemed a consent of the parties to the jurisdiction of the court of first instance of the province or city where any party resides to enforce such contract or submissions. Section 4, Republic Act 876. The preliminary procedures of arbitrations or arbitration shall be instituted. Number 1. In the case of the contract to arbitrate future controversies by the service by either party upon other of the demand for arbitration in accordance with the contract, such demand shall set forth the nature of the controversy, the amount of involved, if any, and the relief sought, together with a true copy of the contract providing for arbitration. The demand, number 2, The demand shall be served upon any party either in person or by registered mail. In the event that the contract between the parties provides for the appointment of a single arbitrator, the demand shall set forth in a specific time with which the parties shall agree upon such arbitrator. That the contract between the parties provides for the appointment of 3 arbitrators, one to be selected by each party. The demand shall name the arbitrator appointed by the party making the demand and shall require that the party upon whom the demand is made shall within 15 days after receipt thereof advise in writing and party making such demand of the name of the person appointed by the second. By the second party in such notice shall require that 2 arbitrators so appointed must agree upon the third arbitrator with 10 days from the date of such notice. Number 3. In the event that one party defaults in answering the demand, the aggrieved party may file in with clerk of the court of first instance having jurisdiction over the parties of copy of demand for arbitration under the contract of arbitrate with a notice that the original demand was sent by registered mail or delivered by a person to be party against whom the claim is asserted. Such demand shall set forth the nature of the controversy, the amount involved, if any, and the relief sought, and shall be accompanied by a true copy of the contract providing for arbitration. In the case of submission of an existing controversy, the filing with the clerk of the court of the first instance having jurisdiction, the submission agreement set forth the nature of the controversy and the amount involved. If any, the submissions may be filed by any party and shall be duly executed by both parties. In the event that one party neglects, fails, or refuses to arbitrate under the submissions agreement, the aggrieved party shall follow the procedures prescribed in subparagraphs A and B of Section 5 of Republic Act 876, Section 5, Republic Act 876. How is hearing by the court in arbitration conducted? Number 1. The party aggrieved by the failure, neglect, or refusal of another to perform under the agreement in writing, providing for arbitration, may be petitioned the court for the order directing that such arbitration proceed in the manner provided for in such agreement. Number 2. 5 days notice in writing of the hearing of such application shall be served, either personally or by registered mail upon the party's default. The court shall hear the parties, and upon being satisfied that making the agreement or such failure to comply therewith is an issue, shall make an order directing to the parties to proceed to arbitration in accordance with the terms of agreement. Number 3. If the making of the agreement or default is in issue, the court shall proceed to summary here such as issue. In the finding instance that no agreement in writing providing arbitration was made, if there is no default in proceeding thereunder, the proceeding shall be dismissed. If the finding is that a written provision or arbitration was made and there is a default in proceeding thereunder, an order shall be made summarily directing the parties to proceed with arbitration in accordance with the terms thereof. Number 4. The court shall decide all motions, petitions, or applications filed under the provision of this Act, with 10 days after such motions, petition, or applications have been heard by it. Section 7, Republic Act 876. Okay. Continue in this chapter 7. When may a civil action be stayed? If a suit or proceeding be brought upon an issue arising out of agreement providing for the arbitration thereof, the court in which such suit or proceeding impending upon being satisfied that the issue involved in such suit or proceedings is referable to arbitration, shall stay the action or proceedings until arbitration has been had in accordance with the terms of our agreement, provided that the applicant for the state is not a default in proceeding with such arbitration. Section 7, Republic Act 876. How are arbitrators appointed? If in the contract for arbitration or in submission described in Section 2 of Republic Act 876, provision is made for the method of naming or appointing an arbitrator or arbitrators. Such method shall be followed. But if no method is provided therein, the court or the first instance shall designate an arbitrator or arbitrators. The court of the first instance shall appoint an arbitrator or arbitrators, as the case may be in the following instances. Number 1, if the parties to the contract or submissions are unable to agree upon a single arbitrator. Number 2, if an arbitrator appointed by the parties is unwilling or unable to serve and his successor has not been appointed in the manner in which he was appointed. Number 3, if either party to the contract fails or refuses to name his arbitrator within 15 days after the receipt or of the demand of the arbitrations, or number 4, if the arbitrators appointed by each party to the contract or appointed by one party to the contract and by the proper court fail to agree upon the select and third arbitrator. Number 5, the court shall its discretions appointed 1 or 3 arbitrators according to the importance of the controversy involved in any of the proceedings case in which the agreement is silent as to the number of arbitrators. Number 6, arbitrators appointed under this section shall either accept or decline their appointments within the 7 days of the receipt of their appointments. In case of declination or the failure of arbitrator or arbitrators to duly accept the appointment, the parties of the court, as the case may be, shall proceed to appoint a substitute or substitutes for the arbitrators or arbitrators who decline or fail to accept their appointments. Section 8, Republic Act 876. What are the qualifications of an arbitrator? Any person appointed to serve as an arbitrator must be a legal age and full enjoyment of his civil rights and know how to read and write. Know to read and write. No person appointed to serve as an arbitrator shall be related by blood or marriage within the 6th degree to either party to the controversy. No person shall serve as an arbitrator in any proceeding if he has or had a financial, fiduciary, or other interest in the controversy or cause to be decided or in the result of the proceedings, or if he has any personal bias that might prejudice the right of any party to fair and impartial word. No party shall select as an arbitrator any person to act as his champion or to advocate for his cause. If, after appointment, but before or during the hearing, a person appointed to serve as an arbitrator discovers any of the circumstances like to create a presumptions of a bias, or which he believes he might disqualify him as an impartial arbitrator, the arbitrator shall immediately disclose such information to the parties. Thereafter, the parties may agree in writing. Number 1, to waive the presumptive disqualifying circumstance, or number 2, to declare the office of such arbitrator vacant. Any such vacancy shall be filed in the same manner as the original appointment was made. May additional arbitrators be appointed? Yes, in Section 9 provides, where a submission or contract provides that 2 or more arbitrators therein designated or to be thereafter appointed by the parties may select or appoint a person as an additional arbitrator. The selection or appointment must be in writing. Such additional arbitrator must sit with the original arbitrator. Such upon the hearing in Section 9, Republic Act 876. Section 9, Republic Act 876. Republic Act 876. What must the arbitrator do if after appointment, but before or during a hearing, a person appointed to serve as an arbitrator discovers any circumstance likely to create a presumption of bias or that he believes might disqualify him as an impartial arbitrator? The answer is, if after appointment but before or during a hearing, a person appointed to serve as an arbitrator discovers any circumstance likely to create a presumption of bias or which he believes might disqualify him as an impartial arbitrator, the arbitrator shall immediately disclose such information to the parties. Thereafter, the parties may agree in writing. Number 1, to waive the presumptive disqualification circumstances, or to declare the office of such arbitrator vacant. Any such vacancy shall be filed in the same manner as the original appointment was made. Section 10, the Republic Act 876. The challenge to arbitrators. Number 1, the arbitrators may be challenged only for reasons mentioned in the preceding section, which may have arising after the arbitration agreement or were unknown at the time of arbitration. Number 2, the challenge will be made before them. Number 3, if they do not yield the challenge, the challenging party may renew the challenge before the court of first instance, the province or city, which the challenge arbitrator or any of them, if there are more than one resides while the challenging incident is discussed before the court. The hearing or arbitration shall be suspended, and it shall be continued immediately after the court was delivered an order on the challenging incident. Section 11, 876, Republic Act 876, Section 11. Question: what is the procedure to be followed by the arbitrator? What are the procedure? Number 1, subject to the terms of submission or contract, if any are specified therein, arbitrator selected as prescribed herein must, with 5 days after appointment, if the parties to the controversy reside within the same city or province, or within 15 days after appointment, if the parties reside in different provinces, set a time and place for the hearing of the matter submitted to them, and much case notice thereof to be given to each of the parties. Number 2, only with the parties' consent can the arbitrators postpone or adjourn the hearing. Otherwise, the arbitrators may do so on their own initiative only during the hearing, and for the good of sufficient reason, there can be an extension of the hearing past the day set in the submission or contract for the making and the award, unless both parties to the submission or contract agree in writing to extend the time limit, or the parties have continued with arbitration without objecting to the extension. Number 3, the hearing may proceed in the absence of any party who, after due notice, fails to be present at the hearing or fails to obtain an adjournment thereof. An award shall not be made solely on the default of the party. The arbitrator shall require the other party to submit such evidence as they may require for making an award. Number 4, anyone who isn't a party to the arbitration, someone who worked for the party and has been given written permission by the party, or practicing a lawyer, which will not be allowed to represent a party to the arbitration in front of arbitrators. Any party wishing to have legal representation must notify the other party or parties of their intention at least 5 days prior to the hearing. Number 5, arbitrators shall arrange for the taking of an stenographic record of the testimony when such a record is requested by one or more parties, and when payment of the cost thereof is assumed by such party or parties. Number 6, person having a direct interest in the controversy that is the subject or arbitrations shall have right to attend any hearing. But attendance of any other person shall be at the discretion of the arbitration. Section 12, Republic Act 876. The question is, what are arbitrators required to take an oath? Question, are arbitrators required to take an oath? Yes, the answer is yes. Before hearing any testimony, arbitrator must be sworn in by any officer authorized by law to administration of an oath, faithfully and fairly to hear and examine the matters in controversy, and to make a just an award according to the best of their ability and understanding. Arbitrators shall have the power to administer oaths to all witnesses, requiring them to tell the whole truth and nothing but the truth in any testimony that they may give in an arbitration hearing. This oath shall be required to every witness before any of the testimony is heard. Section 13, Republic Act 876. Question, do arbitrators have the power to issue subpoena, duces tecum, and ad testificadum? Duces tecum and ad testificadum. Do arbitrators have the power to issue a subpoena? The answer is yes. Arbitrators shall have the power to require any person to attend a hearing as a witness. They shall have the power to subpoena witness and documents when the relevancy of the testimony and the materiality thereof have been demonstrated to the arbitrators. Arbitrators may also require the retirement of any witness during testimony of any other witness. All the arbitrators chosen by dispute must show up to all hearing and hear all the claims evidence from both sides. However, an award made by the majority of them is valid unless the submission or contract to arbitrate make it clear that all of them must agree. Section 14, Republic Act 876. Another question. Do arbitrators have the power to take measure to safeguard and to conserve any matter subject to the dispute in arbitration? The answer is yes. The arbitrator shall have the power at any time for rendering the award without prejudice to the rights of any party to petition the court to take measure to safeguard and or conserve any matter that is the subject of the dispute in arbitration. Section 14, Republic Act 876. How is the hearing of arbitration conducted? Question, how is the hearing of arbitration conducted? Number 1, arbitrators may at the commencement of the hearing ask both parties for brief statements of the issue in controversy and or agreement statements of facts. Thereafter, the parties may offer such evidence as they desire and shall produce such additional evidence as the arbitrator shall require or deem necessary for any understanding and determination of the dispute. Number 2, the arbitrator shall be the sole judge of the relevancy and materiality of the evidence offered or produced and shall not be bound to conform to the rules of court pertaining to evidence. Arbitrators shall receive as exhibits in evidence any documents that the parties may wish to submit, and the exhibits shall be properly identified at the time of submission. All exhibits shall remain in the custody of the clerk of court during the course of the arbitration and shall be returned to the parties at the time of the award is made. Number 3, the arbitrators make an ocular inspection of any matter or premises that are in dispute, but such inspection shall be made only in presence of all parties to the arbitration. unless any party who shall have received notice thereof fails to appear, in which event inspection shall be made in absence of such party. Section 15, Republic Act 876. Question: when may the parties' brief be filed? Number 1 question. Answer: at the end of the hearing, the arbitrators will ask all parties directly if they have any more evidence or witness to present. If all the parties shall still say no, the hearing will end unless the parties have said they want to file brief. Number 2. Then the hearing shall be closed by the arbitrators after the receipt or brief and or reply briefs. A definitely time limit for the filing of such briefs must be fixed by the arbitrators at the close of the hearing. Brief may be filed by the parties within the 15 days after the close of the oral hearings. The reply brief, if any, shall be filed within 5 days. 5 days following such as 15 days period. Section 16, Republic Act 876. Republic Act 876, Section 16. Question: may a hearing be reopened? Answer: yes. The arbitrators have the authority to reopen the hearing at any time prior to the announcement of the award, either on their own initiative or the request of any party, provided that there is a good cause. When hearings are thus reopened, the effective date for the closing of the hearing shall be the date of the closing of the reopened hearing. Section 17, Republic Act 876. Republic Act 876, Section 17. Question: may parties submit their dispute to the arbitrator other than by oral hearing? May parties submit their dispute to the arbitrator other than by oral hearing? Answer: yes. The parties to a submission or contract to arbitrate may, by written agreement, submit their dispute to the arbitration by other means than oral hearing. The parties may submit an agreement statement of facts. Number 1. They may also submit their respective contentions to the duly appointed arbitrators in writing. This shall include statement of facts together with all documentary proof. Parties may also submit a written argument. Number 2. Each party shall provide any other parties to the dispute with a copy of all statements and documents submitted to the arbitrators. Each party shall have an opportunity to reply in writing to any other party's statements and proofs. But if such party fails to do so within 7 days after receipt of such statements and proofs, he shall be deemed to have waived his right to reply. Number 3. Upon the delivery of the arbitrators of all statements and documents, together with any reply statements, the arbitrator shall declare the proceeding in lieu of hearing closed. Section 18, Republic Act 876. Republic Act 876, Section 18. Okay. Proceed. When is the proper time to render the award? The proper time to render an award, unless the answer is unless the parties have stipulated by written agreement the time within which all arbitrators must render their award. The written award of the arbitrator shall be rendered within 30 days after the closing of the hearings, or if the oral hearings have been waived, within 30 days after the arbitrator shall declared such proceedings in lieu of hearings closed. This period may be extended with the mutual consent of the parties. Section 19, Republic Act 876. Republic Act 876, Section 19. What must the form and contents of the award be? Question. What must the form and contents of the award be? Answers. Number 1. The award must be made in writings and signed and acknowledged by majority of the arbitrators, if more than one, and by the sole arbitrator. If there is only one, each party shall be furnished with copy of the award. Number 2. If the arbitrators think it is fair and just, they can give any remedy or relief that fits within the agreement between the parties. This includes, but it isn't limited to, making sure that the contract is specifically carried out. Number 3. In the event that the parties to an arbitration have during the course of such arbitration settled the dispute, they may request of the arbitrators that such settlement be embodied in an award that shall be signed by the arbitrators. Number 4. No arbitrator shall act as a mediator in any proceedings in which he is acting as an arbitrator, and all negotiations towards settlement of the dispute must take place without the presence of the arbitrators. Number 5. The arbitrators shall have the power to decide only those matters that have been submitted to them. The terms of the award shall be confined to such disputes. Number 6. The arbitrator shall have the power to assess in their award the expenses of any party against another party when such assessment is deemed necessary. Section 20, Republic Act 876. Republic Act 876, Section 20. Question. Is arbitration a special proceeding? Yes, the answer is yes. Arbitration under the contract or submission is a special proceeding. The court name in the contract or submission has jurisdiction, or if none is named, the court or first instance for the province or city where one of the parties lives, or the business or where the arbitration took place. Any application to the court or judge thereafter shall be made in a manner provided for the making of hearings and motions, except otherwise herein expressly provided. Section 22, Republic Act 876. When may the order to confirmation of the award be made? When may the order for confirmation of the award be made? Answer. At any time within 1 month after the award is made, any party to a controversial that was arbitrated may apply to court having jurisdiction as provided in Section 28 or any other confirming the award, and thereupon the courts must grant such an order unless the award is vacated, modified, or corrected as prescribed herein. Notice of such motion must be served upon the adverse party or his attorney as prescribed by law. For the service of such notice upon the attorney in action in the same court. Section 23, Republic Act 876. Question. What are the grounds to vacate an award? In any one in the following case, the court must make an order vacating the award upon the petition of any party of the controversy when such party proves affirmatively that the arbitration proceedings, number 1, the award may procured by corruption, fraud, or other undue means, or number 2, that there was an evident partiality or corruption in arbitrators or any of them, or number 3, the arbitrators act badly when they refuse to move the hearings when this was good reason to do so, and when they refused to hear evidence that was relevant to the importance of the case, and one is more, arbitration was not allowed to be an arbitrator under the Section 9 of this law, and purposely avoid telling anyone about their disqualifications or any other behavior that hurt anyone's right. Or number 4, that the arbitrators exceeded their powers or so imperfectly executed them. The mutual final and different award upon the subject matter submitted to them was not made. Number 5, whenever an award is thrown out, the court can choose to hold new hearing with neither the same arbitrators or a new set of arbitrators chosen in the same way that the original arbitrators or arbitrators were chosen. Any clause in the submission or contract that limits the time arbitrators have to make a decision will apply to the new arbitrations and to start from the date of the court's order. Number 6, where the court vacates an award cost not exceeding 50 pesos, and this disbursement may be awarded to the prevailing party and the payment thereof may the enforce is like matter as the payment cost upon the motion in action. Section 24, Republic Act 876. Question: what are the grounds to modify or correct an award? In any of the following cases, the court must make an order modifying, correcting the award upon the application of any party to the controversy that was arbitrated. Number 1, where there was an evident miscalculation or figures or evident mistake or description of any person, things, or property referred to in the award. Or number 2, wherein the arbitrators have awarded upon a matter not submitted to them, not affecting the merits of the decision upon the making submitted are. Number 3, if the award is flowed in a way that doesn't affect the substance of the case, and it had been a commissioner report, the court could have fixed the flow or ignore it. Number 4, the order may modify and correct the award so as to affect in its intent and promote justice between the parties. Section 25, Republic Act 876. Now, question: when should the notice of motion to vacate, modify, or correct the award be served? Answer: notice the motion to vacate, modify, or correct the award must serve upon the adverse party or his counsel with 30 days after the award is filed or delivered, as prescribed by law for the service upon the attorney in an action. Section 26, Republic Act 876. There's too many. Okay. When may the judgment be made? Upon the granting of an order confirming, modifying, or correcting an award, judgment may be entered in conformity with therewith the court wherein said application was filed, the cause of the application, and the proceedings submitted thereto may be awarded by the court in its discretion. If awarded, the amount thereof must be included in judgment. Section 27, Republic Act 876. Question: what are the papers that must accompany the motion to confirm, modify, correct, or vacate the award? Answer: the party moving for an order confirming, modifying, correcting, or vacating an award shall, at a time that such motion is filed with the court for the entry of judgment thereon, also file the following papers with clerk of court. Number 1, the submission or contract to arbitrate, the appointment of arbitrators or arbitrators, and its written extension of the time, if any, within which make an award. Number 2, a verified copy of the award. Number 3, its notice affidavit or other prior paper used upon the application to confirm, modify, correct, or vacate such award, and copy of its court order upon such application. Number 4, The judgment shall be docketed. Number 4, the judgment shall be docketed as it were rendered in an action. Number 4, the judgment shall be docketed as it were rendered in an action. Number 5, the judgment so entered shall have the same force and effect in all respects as be subject to all provisions relating to a judgment in an action, and it may be enforced as it had been rendered in the court in which it is rendered. Section 28, Republic Act 876. When may an appeal to be made? Question. When may an appeal be made? Answer. 1. An appeal may be taken from an order made in a proceeding under his act or from the judgment entered upon an award through temporary proceedings, but such appeals shall be limited to question of law. Number 2. The proceeding upon such an appeal, including the judgment thereon, shall be governed by the rules of court in so far as they are applicable. Section 29, Republic Act 876. Question. What is the consequences if a party dies after making a submission or contract to arbitrate? Answer. 1. Where a party dies after making a submission or a contract to arbitrate as prescribed in this act, the proceeding may be begun or continued upon the application of or notice this executor administrator or a temporary administrator of his estate. In any such case, the court may issue an order extending the time within which notice a motion to confirm, vacate, modify, or correct an award must be served. Number 2. Upon compounding an award where a party has died since it was filed or delivered, the court must enter judgment in the name of the original party, and the proceedings thereof are the same as where a party dies after verdict. Section 30, Republic Act 876. Here is the table in dispute resolution and crimes management. Question. What are the distinctions between retributive justice and restorative justice? Question. What are the distinctions between retributive justice and restorative justice? Okay, the first table here is retributive justice, and the other is the restorative justice. Here in retributive justice, number 1, what law was broken? Number 2, who broke it? And number 3, how will offenders be punished? Number 4, considers a crime as an act against the state. Number 5, the control of crimes lies with the criminal justice system. Number 6, the community is represented by the state. In restorative justice, number 1, what is the harm that resulted from the crimes? Number 2, what needs to be done to repair the harm, and who is responsible for repairing the harm? Number 3, who is responsible for repairing a harm? Number 4, considers a crime as an act against a victim and the community. Number 5, the control of crimes lies with the community. Number 6, the community is the facilitator in the restorative process. Okay, in restorative justice table, focused on the past by determining the person to blame for crime committed. In restorative justice, it focuses on the future to determine the matters to be considered so that the crime will not be repeated. In restorative justice, focus on the offender's past justice. In restorative justice, focus on the consequences of the offender's behavior. Restorative justice emphasizes the adversarial relationship. Restorative justice emphasizes dialogue and negotiation. Retributive justice considers crimes to be an individual act with individual responsibility. In restorative justice considers crime to be both an individual and social responsibility. Retributive justice, based on the principle of lex talionis. Restorative justice, based on forgiveness and reconciliation. Okay. Here is your activity number 7, instruction. Select the correct answer for each of the following questions. Okay, multiple choice. Only 5 items to be answered. Number 1 question. How should an award be made according to Section 20 of Republic Acts 876? How should the award be made according to Section 20 of Republic Act 876? Letter A, verbally and anonymously. B, bravo, in writing, sign, and acknowledgement by the majority of arbitrators. Charlie, only by the sole arbitrator. Delta, only in presence of the parties. Number 2 question. What authority do arbitrators have the providing remedies under the agreement between parties? What authority do arbitrators have providing remedies under the agreement between parties? Alpha, limited to monetary compensation. Bravo, limited to enforcing the terms of original contract. Charlie, can provide any remedy or relief within the agreement. Delta, must refer all matters to the court for decisions. 3. What can be done if parties settle the dispute during arbitrations? Alpha, the arbitrator can ignore the settlement. Bravo, the settlement cannot be embodied in an award. Charlie, parties cannot request the settlement to be embodied in an award. Delta, they may request the arbitrators to embody the settlement in an award. Number 4 question. Can arbitrators act as a mediator in the same proceedings? Alpha, yes, if requested by the parties. Bravo, no, under any circumstances. Charlie, only in both parties' agreement. Delta, only if the court permits. Number 5 and last question. What matters can attributed decided according to Section 20, Republic Act 876? Alpha, any matter they deem fit. Bravo, only matters explicitly mentioned in the original contract. Charlie, only matters submitted to them. Delta, only commercial dispute. Now here is the key answer in activity. In this activity. Activity 7, 1 Bravo, 2 Charlie, 3 Delta, 4 Bravo, and 5 Charlie. Thank you for watching this chapter 7.